And on that note, we will slowly start. So first of all, I would like to introduce myself and our other speakers today. My name is Joab. I'm the Executive Director of Better Finance. We are the European Federation of Investors and Financial Services Users. So we represent the regular EU citizens as small individual investors and other users of financial services. So the persons saving and trying to improve their retirement or their general economic well-being by investing in securities and other listed investments. With me today to talk about this case is Philip, whose last name I don't dare to pronounce, but who is the chairman of the Fiat Chrysler Investor Recovery Foundation, and Jan-Willem de Jong, who is a partner at the law firm Scott+Scott. So before I give these esteemed gentlemen the floor, I will highlight very shortly why we're here. So we're talking about both collective redress in the European Union in general, and about in particular the Fiat Chrysler automobile, or now Stellantis investor redress case. And why is legal redress and in particular collective redress very important is because when people save for the long term and try to improve their economic situation by investing, which is also something very positive for the wider economy as well, then they depend on the companies, both that they invest in, but also the intermediaries, to play by the rules. And the vast majority of companies do, and that's why in the long run, investing in the stock markets is always profitable as long as you do it in a diversified way. However, sometimes there are still some bad actors, and in these cases, to protect the small investors and EU citizens, there needs to be adequate redress. So legal redress, and especially for the normal citizen, the important thing is collective redress, because if you are as an ordinary worker, you have because of being misled by a company, you have lost some thousands of euros. Then for you, this is probably a very significant harm. However, it is not feasible for you to and economically rational to on an individual basis pursue a case against the company or people that misled you. So this is why it's required to pursue these cases collectively, so that hundreds, thousands, maybe even tens of thousands of investors can pool their cases in an economic way. So this is also why Better Finance and many of its member organizations have either sometimes joined and led collective redress cases, and in the case like here, we help to disseminate information and inform investors about this possibility, while also calling on policymakers to improve the existing system. But now, without further ado, I give the word to Philip, who will tell you more about this case in particular.
Thank you. Good morning, buongiorno. My name is Philip Schreurs, and I'm the chairman of Fiat Chrysler Investors Recovery Foundation. I appreciate you taking the time to join this press conference. Today, I will try to provide a factual and structured overview of the legal case concerning Fiat Chrysler's use of unauthorized diesel emission software. This case is important not just for environmental reasons, but for investor trust, for corporate accountability, and financial transparency. Between 2014 and 2017, thousands of investors, particularly in Europe, invested in Fiat Chrysler shares with the understanding that the company was operating lawfully. They trusted that the vehicles met all legal emissions requirements. However, we now know that this trust was misplaced. Fiat Chrysler systematically misrepresented its emissions compliance using illegal software, often called cheat devices. And that software allowed vehicles to pass emission tests under controlled conditions while significantly exceeding legal pollution limits in real-world driving. Regulatory investigations in both the United States and Europe have confirmed this deception. The US Environmental Protection Agency, EPA, and the California Air Resources Board, CARB, uncovered evidence that Fiat Chrysler concealed the use of these devices. The company repeatedly denied any wrongdoing until the legal pressure became undeniable. For investors, the consequences were severe. When the truth came to light, Fiat Chrysler's stock value dropped. Those who had purchased or held shares in the company during this period suffered substantial financial losses. To fully understand the case, we must go back to 2015, when the Volkswagen diesel emissions scandal made global headlines. At that time, regulatory agencies worldwide began testing diesel vehicles from other manufacturers, and Fiat Chrysler was among the companies investigated. In September 2015, shortly after Volkswagen admitted to emissions fraud, US regulators began also questioning Fiat Chrysler. The company issued a public statement denying any wrongdoing, insisting that its vehicles met all emission standards. However, internal documents now reveal that Fiat Chrysler was already aware of serious compliance issues. As the investigation continued, authorities discovered Fiat Chrysler had programmed its diesel engines to behave differently in test environments. Under controlled conditions, the vehicles appeared to meet emission standards. But on the road where real-world driving conditions applied, the engines produced significantly higher levels of nitrogen oxides, harmful pollutants as we all know, linked to respiratory problems and environmental damage. Over the next 2 years, Fiat Chrysler continued to deny any involvement in emissions cheating. The company's executives, including then CEO Sergio Marchionne, repeatedly reassured investors and the public that their vehicles complied with the law. Meanwhile, regulators in the United States, Germany, and France gathered mounting evidence that Fiat Chrysler was misleading authorities. Reports confirmed that Fiat Chrysler vehicles had been fitted with undisclosed software designed to alter emission readings. In early 2017, the US Environmental Protection Agency formally accused Fiat Chrysler of using illegal emission software. This triggered legal action, and in May 2017, the US Department of Justice filed a lawsuit against the company. The stock market reacted immediately. Investors who had relied on Fiat Chrysler's uninterrupted assurances of compliance saw their holdings lose value almost overnight. Despite mounting evidence, Fiat Chrysler maintained its denial for years. It wasn't until 2022 that the company, then part of Stellantis, formally admitted to emissions fraud in a settlement with US authorities. The company agreed to pay a criminal fine of approximately $300 million. This was in addition to previous civil penalties and investor settlements in the United States. Stellantis, I would like to emphasize, explicitly admitted its wrongdoing. The financial damage to investors was significant. Those who had bought Fiat Chrysler shares between October 2014 and May 2017 did so under false pretenses. During this period, they constantly were led to believe that the company was compliant with emissions regulations, when in reality, it was actively concealing violations. While US investors have already received compensation through legal settlements, European investors have yet to be compensated for the losses. Our Fiat Chrysler Recovery Foundation was created to address this issue and to ensure that affected shareholders in Europe receive the compensation they are entitled to. The legal claim filed under Dutch collective action law, WAMCA, is based on our assumption that we can prove that Fiat Chrysler first provided false or incomplete information about its emission compliance, second, denied the existence of emissions cheat software despite internal knowledge of its use, and finally, continued to mislead investors and regulatory agencies, causing financial harm when the truth emerged. These are not allegations, these are facts, supported by legal filings, regulatory investigations, and Fiat Chrysler's own admissions. Now, I would like to turn to the legal approach we are taking to address this case and ensure that European investors receive the compensation they are entitled to. I would like to give the floor to Jan-Willem de Jong, who is our lawyer in the pending case.
Thank you very much, Philip, and good morning, everyone. Thanks for taking the time to be on this call this morning. I'm indeed Jan-Willem de Jong. I'm a partner at Scott+Scott in the Amsterdam office, and I act as the lawyer of this foundation. And as a lawyer of the foundation, I will turn to the more legal aspects of this particular matter, but as Martis in his introduction also mentioned, we may turn upon like more fundamental differences between how the legal regimes differ in Europe, but most importantly, how they also differ from the US and what that translates to in the legal position of investors who, as in this case, may actually invest in exactly the same share, but are not given the same means to recover their losses. So first of all, let's turn to the legal basis of this case. So the foundation brought proceedings under the Dutch collective action regime. And the law was changed in 2020, and as of then, it allowed foundations to seek monetary relief. So they could claim real damages for a collective, for a group, not for individuals, but like an entire class of, in this matter, investors. And that ensures that investors who suffered financial loss due to corporate misconduct can seek justice as a group. Then turning to the more specific elements of this case, under Dutch law, companies that mislead investors and cause financial harm can be held legally responsible. The facts of this case clearly show that back in the days, Fiat Chrysler's actions meet that threshold. But also European law protects investors against corporate misrepresentations and aims to avoid market abuse. The principle of transparency is at the heart of financial markets. Investors must be able to rely on corporate disclosures, and when a company misleads the market, it distorts the decision-making of investors, ultimately leading to financial loss. And that is precisely what has happened in this case. Then let's turn to the more geographical elements. So why the Netherlands? So first of all, Fiat Chrysler and later on Stellantis are incorporated under Dutch law, and its headquarters are in the Netherlands. It is an international company with global operations. The place of its effective management is situated in the Netherlands. In the Netherlands is also Stellantis' home member state for the purposes of the EU Transparency Directive. The matter, therefore, belongs clearly to the Netherlands. And that, secondly, apart from being its home member state, the legal system in the Netherlands currently might be also the best equipped in Europe to hear a matter dealing with harmed investors from numerous European countries. Unlike many other European countries, the Dutch executive action regime allows investors from multiple jurisdictions, from the Netherlands, Italy, but also from all other countries, to seek justice through one single legal proceeding. But it's important to note that European investors, however, need to register for the claim to be able to proceed, and for those investors to be able to benefit from the outcome of the proceedings. And investors can easily do so through going to the website of the foundation and fill in like an online form. And the foundation encourages like investors to do so. So let's turn now to the legal proceedings that the foundation has on foot and the next steps therein. So the legal proceedings were launched by the foundation in August of last year, and Stellantis is scheduled to submit its defense by the end of this month. And in the first phase, the proceedings are dealing with the admissibility of these proceedings, whether the claim can be brought. And that will be heard in June of this year. And we are quite confident that the foundation will meet that threshold and that the proceedings then can proceed to the merits, dealing with the liability of Stellantis, but also assessing the damages suffered. And when we turn to like the remedies and the losses, I think it's also good for investors and everyone on this call to understand what the foundation actually tries to achieve. The foundation is seeking fair financial compensation for European investors who suffered losses due to Fiat Chrysler's misconduct. This compensation will be calculated based on the decline of the share price following disclosures about the fraud by Stellantis. We recognize that no financial remedy can fully reverse the damage done to investor trust. However, compensation is a necessary step in restoring fairness to those who invested in Fiat Chrysler under false pretenses. And it also sends a clear message to other listed companies to take their transparency obligations serious and to comply with applicable regulations. And as Philip also mentioned, it is important to know that a claim in relation to exactly the same shares listed in the US settled already. Stellantis paid in 2019 already $110 million to affected investors that traded through stock exchange in the US. Investors that traded in Europe, however, have received nothing to date. And the foundation wants to close that stark contrast, as all investors, at the end of the day, were misled exactly in the same way. The goal, therefore, is simple: to ensure that investors that traded in Europe receive the same fair treatment their counterparts already received in the US. Even more so, because after the US settlement, Stellantis reached a plea deal to avoid criminal proceedings and confirming the misconduct. So from a factual perspective, the claim of investors actually has become stronger since the settlement in the US was reached. So in the interest of time, let me wrap up with some final comments. This case is more than just about emission fraud. It is about a fundamental principle of corporate transparency, investor protection, and financial accountability. Stellantis knowingly misled investors, and Stellantis now must face the consequences. It accepted that it required to compensate investors in the US, and now it's time to compensate investors that traded in Europe. And the foundation is very happy to cooperate on this matter together with Better Finance, and gives me a good opportunity to hand over back to you, Mathis.
Thank you very much. And I will just, as a closing statement, zoom out even a bit more to highlight the importance of this case, but also collective redress in general on some of the very important policy debates that are happening both in Brussels and in many national capitals. Because some of these have been already alluded to by Jan-Willem and Philip. So first of all, a very big topic today is across Europe is competitiveness of our economy, and the challenges we face in terms of the transitions, whether it is the sustainability transition, digitalization, but also our security. And to handle these big challenges, including also aging population, there needs to be more investment. And this investment is through the best channel, the most effectively channeled through capital markets. However, in the EU broadly, what we have and what one of the main reasons we are falling behind other major developed economies is that most people do not invest, and most savings are lying in bank accounts where they neither benefit the economy nor benefit the people. So this is very important both for the savers themselves, because again, as an aging society, how to finance our retirements, a dignified retirement, is very important. We have a pension time bomb in this sense, where the pay-as-you-go system cannot provide everyone in the future sufficient dignity. So we have to have another lever for this. So, and if people are keeping a large part of their savings just in cash or bank accounts, then as we've seen in the last years, inflation will destroy the purchasing power of those savings. So it is very important that and indeed safer for people to invest than to keep them in cash. So that's one very important side, and that for the people, but that also will help turbocharge the innovation in the economy and finance meeting the challenges that Europe currently faces. However, to do that, people need to have security. People need to have trust in the markets, and that there will be free, fair play, and that there will be adequate safeguards in the case that that things don't work or there's any misleading. Here, it's also a question of competition, because we have seen that the European capital markets have become increasingly small when compared to competitors around the world, in particular to the US. And here one of the reasons undoubtedly is, there's many reasons why the US market works better, but one of them is that investors can also gain sufficient redress, and we cannot hope to build a competitive capital market, a competitive savings and investment union, if we have these cases where US investors have been paid out long ago and the European ones not. Then it creates the question, why should anyone invest in the EU markets? So that's why it's very important. The other big level debate we are having across Europe is simplification of regulation, that we do not want to drown our economy and our companies in red tape. However, we also do not want to become the Wild West where everything goes. So there needs to be a balance, and one of the best and most efficient ways to balance this is not to regulate every small detail, but to make sure that when principles are not respected, when principle-based legislation is not respected, then there are consequences and there's effective redress. And then finally, also it's a case of fairness among in the EU member states. As my colleague said, currently under Dutch law, and this is the experience of also many of our member organizations across Europe, that even when it comes to cases against companies who are not headquartered in the Netherlands and who are not listed in the Netherlands, it's often the best place to bring a redress case, because the national frameworks in many countries are very difficult for these cases. Just the simple things like how to register the people, because if you make it so difficult and so bureaucratic that registering every single person takes entire working day, then of course you will not have effective redress. So that is also a question of the fairness among the member states. In this sense, Better Finance was very disappointed when the European Union collective redress directive, which was passed some years ago, left out direct investors, that it allowed for consumer redress in other fields, but not in the case of direct investors. So this is a very important point which we call on the European Union to address when this directive comes up for review. And on that note, I will close with the statements and invite all your questions, and we will be happy to answer. Thank you. Are there any questions in the chat?
Hi, everyone. Thank you. I was just wondering, by when can an Italian investor join the class action?
So we will have a hearing, as I said, in June, and that moment in time, the court will assess whether the foundation is sufficiently representative. And that means, like, what has the foundation done? So investors should and must register before then, and I think the current thinking is that should be by the end of April, to ensure that the registrations can be completed in time, and give us sufficient time to process that and to be relevant for that consideration. So it's a long way of answering your question, but I mean, in short, I think the sooner the better. But certainly by the end of April, I think investors should have been able to go through that quite simple online form, which is available in Italian, Dutch, and English.
Mm-hmm. And I will just add that of course more information on this case is available at their website, as well as this form. The link was in the press release and in the invitation to this press conference, but my colleague will also add it just in case to the chat. So whenever any of you might disseminate this information to others, to be able to include the link where people can get more information and in fact sign up for this case.
Great, thank you.
Welcome.
So any other questions? In the meanwhile, I will also then just I would like to say that this topic, especially when it comes to the EU framework, will be discussed further by Better Finance, and for example, it will also feature prominently in our International Investor Conference, which will take place on the 12th of June. So, and which will be in Madrid, but also possible to attend online. So I would encourage all of you to also tune in to that and then join us if possible. Yes. So I'll give it just one more minute, so anyone who would like can raise their hands and ask a question, or quickly just type it into the chat.
Just to say hello to everybody, and to speak to Italian followers. You can find everything in Italian after this convent.
Yes, exactly. We will be both publishing an article, and if actually my colleagues here are allowed, then we will also share the speaking notes that we spoke about. So it's also in case you would be writing any article, whether in Italian, in French, and in German, or any other language, it's easier to translate with all the nice AI tools we have.
And the website is also available in Italian, so if you want to see more information.
Exactly, and we have also a question in the chat that you are representing both institutional and retail shareholders.
Yeah, that's true. And already several thousands of individual shareholders have shown their interest, and
also institutional investors. So it's a mix, and I think it's important to represent all. I mean, I think in particular for retail investors, this actually is a good opportunity, and maybe the only opportunity for them to seek relief, because as Martis mentioned initially in the initial remarks, for them it is like basically impossible to do it on their own. So they need to group, and I think that is more fundamentally, I think in most European jurisdictions, the problem, and that needs to be solved. How can you ensure that people with sizable losses, but not like on an individual basis, like enormous, that they can still seek together relief? And I think in Europe we have still a steep learning curve to go through.
Yes, exactly. Here we would highlight one key recommendation and demand from Better Finance on this is rather than having this kind of opt-in process where every single person affected needs to find out about the register, and in some cases, and unfortunately, in many cases, in many countries, they have to provide also a lot of documents in advance to even prove that they are affected. Whereas we call for an opt-out system, which is also the case in some countries in the world, including the US, where all affected people, or in cases like this, affected shareholders, but also in consumer cases, anyone who bought the car with the under the misleading premises, that all who are affected are by default also opted in to the case, and in case they do not want to be part of it, they can opt out. And of course, you cannot, if there is no settlement, you cannot ask them but it, by definition, they are, if there is a settlement or if there is a decision, then everyone who was affected will receive the redress. So this is, in our view, much better.
and that is also the Dutch system.
Well, the Dutch investors are indeed captured, as you said, like on an opt-out basis, but for non-Dutch, they need to opt in. So there's a difference, and I think for that reason, for non-Dutch investors, it's even more important to come forward and register. And to the point of cost, like register is at no cost, in the sense that you do not have to contribute into the costs of the proceedings. But if the case is successful, there's a part that goes to the party funding the case. But I think that is the best option that we currently have in Europe, and that is also court obscene to avoid this is all proper. So
yes, exactly. And as we called, it would be better if this, if in all member states, this kind of, there was a opt-out framework, and that this opt-out framework would apply to all EU citizens and not just to the member state. Because if we're talking about the single market and a single capital market union or savings and investment union, then this is a very critical and obvious step. And also one last comment on this point, it's since of course more retail investors and individuals invest through institutions, so through investment funds or sometimes unit-linked insurance contracts, then it is also very important for individual investors that that these funds would also actively participate to the cases. This is also in line with the basic stewardship, good stewardship guides that these asset managers should follow. But also in this case, even though these funds, the amounts involved will be much larger, and in some cases they would be able to pursue also individual litigation, then still it is much more efficient for these funds and ultimately for their beneficiaries, for their end investors, so EU citizens, if there is an easy and no nonsense possibility of joining collective cases, so that also for them the costs are reasonable. Okay. So on that note, if there are no final questions, then and I thank you all very much. And more info is available on the foundation website, on the Better Finance website, and our communication officer will also be in touch with additional details and materials. Thank you.
Thank